Hello, good morning. Today is the fourth and the last day of the European Conference on Architecture and the Media. This day is dedicated to a cross-cutting topic in the dissemination of architecture, the architectural image. Together with the lawyer Enric Enrich and the prestigious front row of architects, photographers, and institutions, we will touch the most relevant aspects of the copyright in the architectural image. And at 5 p.m., we will have with us the photographer Ivan Ban for the closing conversation of these 4 intense days of talks and debates. As in the conversations of the last days, the purpose of this workshop is not to find solutions. It would be impossible with so a short time. But the purpose is to share our experience and to put them on the table, to point out the relevant topics related with the copyright of an architectural image. So I give the floor to Ivan Blasi, curator of prizes and programs of the Fundació Mies Rohe, that is organizer of the event together with Labóh.
Thank you very much, Miriam. Hello, everybody. As Miriam was saying, welcome to the 4th session of the 2020 European Conference on Architecture and the Media, which is part of the ongoing debates around the European Union Prize for Contemporary Architecture Mies van der Rohe Award, which is organized by the Fundació Mies van der Rohe in Barcelona with the support of Creative Europe, the program of the European Union. And this time it is also in the framework of the Barcelona Architecture Week, which is being very successful, and everything is online, obviously, this year. I wish to thank all those people that are making all this possible, especially Labóh and Linka and the media partners, all the participants, and all of you who are following us. This is life. It's the morning in Europe and Africa, afternoon or evening in Asia and Oceania, and not even daybreak in America. We hope we can soon meet you all where I am right now, the Barcelona Pavilion, but this year we are online and staying at home. Today's workshop on copyright and architectural images will take place with Enric Enrich, lawyer at Copyright Law Firm, joined by Elena Ugas, also a lawyer and the legal advisor of the Catalan Association of Architects, Adrià Goula, who's an architect and a photographer, Alejandra Liébana, Chief Communication Officer at Batlle i Roig Architects, Martin Boschart, Marketing Director at the online platform World Architects, Miriam Giordano, who you have just met, who's the communication specialist at Labóh and curator of this event, and Ducho Malagamba, architect and photographer, who actually who in the first edition of Architecture in the Media in 2018, promoted the idea to discuss even much more, and it was really necessary, on photography and image in architecture. If I take a photo of the Barcelona Pavilion right now, what can I do with it? I could publish it on social media, use it for my classes with students, use it for a thesis, use it to publish a book, make postcards with it, edit it, transform it into a work of art. Which rights does the Mies van der Rohe Foundation have? Which rights do Mises Heers have? Is it the same if the photos taken from the street out there or from over here? What of the photos from 1929? What if there's an art intervention in this pavilion, like many times happens? What if I were a well-known photographer? What if this building were not by a famous architect? What happens when the author of the design is alive? Which rights does the architect, so the designer, have, or the photographer, the client, or the inhabitant? When using images in the EU Mies Award, are we as a public institution promoting the work of the architect and also that of the photographer? Which are the boundaries? Open source photos, photo banks, Creative Commons? Okay, yeah. That's a lot of questions, and these are only some of mine. Time is limited, so let's begin listening to Enric Enrich and then continue the conversation with all our guests and your own questions, which you can write down in the chat on YouTube and Facebook. Thank you.
Good morning. Welcome all of you to this workshop on copyright and architecture and photography and the balance between these copyrights and the property rights of the owner of a building. I want to thank Mies Foundation and Labóh for inviting me to participate in this seminar and share the knowledge with all of you. Copyright protects original creations. Original meaning those that reflect the creative choice of the author, its personal stamp. Also, those creations that are independently created by the author. Amongst others, copyright protects architectural works and photographic works. Concerning architectural works, the layers of copyright protection are two. First, the designs, plans, drawings, and models, that is, all the works which precede the building, and the building itself. The building itself, which will be limited by certain rights like the freedom of panorama, or maybe the property right of the owner, or the public interest. Photographic works also have a double system of protection. We have original photographs, which reflect the author's free and creative choices and show the author's personal stamp in the work, like, for example, an Ansel Adams photography of a landscape, and what we may call other photographs, who have a lower degree of originality, lower creative content, which basically reflect reality without giving space to the creative choices of the photographer. Some countries regulate these other photographs as a specific neighboring right, like, for example, Germany, Austria, Spain, we call them metafotografia, Italy and Denmark, Finland, Sweden, Iceland, and Norway. These lesser photographies have a shorter term of protection, like, for example, 25 years, and don't have the transformation right. Copyright is ruled by each country's laws. That does not mean that there is a certain uniformity at international level due to international conventions, like, for example, the Berne Convention, and also on the European level on the basis of EU directives, which tend to harmonize certain basic aspects of copyright in the different countries. The rights of authors, of architects and photographers, are basically of two kinds. Exploitation rights. The author has the exclusive right to authorize any exploitation of the work, like reproduction, distribution, transformation, public performance. These rights may be transferred by contracts normally. And moral rights. Moral rights, for example, the right to claim authorship of the work and the right to object to any deformation which may be prejudicial to the author's honor, which are non-assignable, which will remain always in the hands of the creator. How different are local laws depending on every country? In the world, we have two major copyright systems. The droit d'auteur system, which is applicable in continental Europe and Latin American countries, basically, and the copyright system, which is applied in the US, Australia, Canada, and in certain ways in England. But within these big systems, every country regulates copyright as it considers convenient. For example, in the US, there is the institution of the work made for hire, by which the employer owns directly and originally all the copyrights on the work. So when an architect is employed by a firm to create a project, the work will be owned by the firm. When a photographer is contracted by someone to produce certain photographs, the rights will belong to the person contracting that photographer. On the droit d'auteur systems, it's not like this. The photographer will be always the right holder of his or her creations, and the architect the same. If someone else wants to use those creations, there will have to be a transfer of rights. Then every country will have different regulation in detailed matters, like what we said before of other photographs or the panorama right, which we will explain later. The term of duration of copyright is essentially the life of the author plus 70 years, after which the work falls in the public domain and it can be used by anyone. In relation to the photographer-architect contracts, normally the architect will commission a photographer to take some pictures, some photographies of his or her building, and the architect would want to have the photographs, and the photographer will want to be paid. So there will be normally an invoice. In general, there is not a specific contract that regulates this transfer of copyrights on the photography. We have to stress that copyright laws are made to protect the authors, and the author of the photography of a building is the photographer, not the architect. Photographers are more conscious of their copyrights because the ordinary way of exploitation of photographies is by rights licensing. Let's imagine in fashion photography, photographers license for a specific term, for a specific territory, for a specific way of exploitation, and they are very used to license photographies on a piece-by-piece basis. Architects license or deliver the project to the owner, to the builder, to the promoter, and normally are not so much worried about secondary exploitations of their work. We have to stress or note that ownership of a work, like ownership of a building or ownership of a photography, does not imply ownership of the rights, of the copyrights. For example, if I own a copy of this work, that does not mean that I can reproduce it in postcards, in posters, in t-shirts, whatever. The transfer of rights, of copyrights, has always to be made by contract, always to be made on written. An invoice is not a way to regulate transfer of copyright. Contracts normally state the different rights of the owners, the different ways of exploitation, the exclusivity or not, the territory of exploitation, the term, and the reservation of rights. In the relationship between the photographer and the architect, all these items or topics should be covered. So if the photographer wants to keep certain rights on the photography, he or she should stress this in the document. If the architect wants to use the photographies for other uses than the initially foreseen, he or she should take care of acquiring the wider possibility of rights. Differently from ordinary property rights, copyright is not unlimited. Copyright has certain limitations and exceptions on economic rights. That is, cases in which protected works may be used without the authorization of the copyright owner and without payment of any compensation. We call them free uses. In the US, it's called fair use, fair dealing, which is a balance between copyright and the right of other people who wants to use these economic rights of the author. The basic limitation of copyright is the term of duration. After a certain term, we have said that there are no more rights. But within the period of protection of copyright, there are other limitations, which essentially, in relation to the topic of this workshop, are first, the freedom of press, freedom of information, which permit to reproduce any work for purposes of informing. We saw the other day Oliver Wainwright from The Guardian talking about his work on documenting new projects with or without the authorization of the owner of the building, of the copyright of the architect. The Guardian can publish and reproduce buildings. Another exception is the citation for educational or investigation purposes. And an important limitation or exception is for what refers to the buildings, not to the drawings or designs or interior design, the possibility of reproducing a work which is permanently located in a public space. The European Union Directive of 2001 provides the possibility of member states having this freedom of panorama clause in their copyright laws, but does not require such a rules. So the different member states have or do not have this panorama right. In the UK Copyright Designs and Patent Act regulates that works which are permanently situated in a public place or in premises open to the public may be photographed, may be filmed, may be broadcast this image without infringing the copyright of the architect of that work, of that building. In Germany, for example, the permission applies only if the image is taken from public ground and without any further utility, like a ladder, like a lifting platform, or like drones. For example, if the building is behind a wall and you use a drone to take a picture of the building, that will not be exempted from copyright. In Spain, we have the regulation which says that works permanently situated in the public space can be reproduced in photography or in video. France and Italy have this limitation only on certain very specific cases and based not on laws but on case law.
Thank you very much, Enric. We knew that there were many aspects to tackle. We have Elena Ugas, who represents today the Catalan Association of Architects, and for sure has received many, many questions during all these years regarding the topics that have come up. Thank you, Elena.
Sorry, good morning. First of all, in the name of the college, I would like to thank Mies Foundation for inviting our association to this event. I am a lawyer of the College of Architects, from where I have been giving legal advice to them about all of the aspects of the profession. Concerning to the intellectual property, we mainly have given advice about the protection of the copyright between the architects themselves, and sometimes about also questions related with third parties as the owner of the constructions or the media. The college considers that architecture must be protected as a common good. In 2018, the Catalan architecture law establishes that architectural creation is a matter of public interest. For the very first time, a law gives this category to architecture. The college believes that the current legal system should do one step further concerning to the protection of the architecture as an asset of public interest, regarding its public and cultural dimension and paying specific attention to the constructed buildings. We also think this issue must be treated differently from other artistic activities because of this public dimension, which designs the places where the human life develops. I would like to remind that the Catalan architecture law provides that some of the values of this art that need to be protected are, amongst others, improving the life quality of people, defending his well-being and comfort in a safe environment, and the contribution to social cohesion, improving the relationship of the citizens with their artistic and cultural dimension. This discipline so has particularities, especially when we talk about erected buildings. As Enric said, if the buildings are in public spaces, the exploitation rights are free for everyone in Spain, what is called the panorama right. And is in the essence of architectural works to be always or almost always in public places, in the streets and squares. And so architects are not in the same condition as other artists that are holders of these rights over their works in an individual way. Not to mention other architectural expressions as urban planning, public spaces design, or landscapes that are also always placed in a public space. Maybe through the way of defending the architecture as a matter of public interest, we can find in the future different ways to put in value the discipline in itself and the rights of the architects. As my colleague said, the architectural work manifests itself on two different levels, the project and the building. The protection of the right over the project, it's quite solved because of the similarities with other written creations, although it has its specificities. For example, in the reproduction of the project, for example, of the plans of a house, it's necessary to take in account the right of privacy of the owner. So I always recommend to ask for a previous authorization, or at least to delete the information about the address and the name of the owner in the website, publications are everywhere. And this goes also for the media. But the protection of the rights over the building does not exactly fit in the current legal framework because we do not have a specific regulation for these cases. The constructed original and singular buildings can be qualified as usable art or as art that where you can live. And this functionality puts at risk the protection of the author rights that occasionally can be affected by the free decision of the owner. It is because of this that the college defends the architecture as a matter of public interest, to reinforce the right of the author in these cases, and also in order to protect the architectural heritage as a common good. This affects, for example, the right of integrity over the architectural works, because the current law does not regulate the specific consequences when the original creation is a building. And the reality is the courts, in these cases, do a balance between, for instance, the right of the owner over his house and the copyright of the architect over the original conception of it. As a result of that, sometimes the needs and desires of the owner over his property can have a certain priority over the copyright of the architect. Our aim as a college is that this balance has to be between the owner on one side and the architect and the community defending its values in the other side. Another situation that we have sometimes attended from the college is the exploitation right of an erected building. The thing is that the exploitation of buildings images needs the previous authorization by the author if they are not taken from the public space. So the producer of an advertisement or a press media that want to use images or a video of the building will need a contract with the architect first. A way to avoid problems in the future, especially with the client, is to add a contract clause about the exploitation rights stating the will of both parties about the future. For example, about the possibility to publish the plans on the website to press media or specialized publications or even professional awards. The images of the building also imply the rights of the photographer that must be taken in account. So the right to publish an image, as my colleague said, involves often three parties: the owner, the architect, and the photographer. In conclusion, it would be convenient to rethink the copyright rules around the architectural works and especially around the specificities of the constructed buildings. And until then, our college and the authors will need to fight hard defending its rights, maybe start a negotiation with the owner or the media, and even in some cases go to the court. Thank you.
Thank you, Elena. Adria, I'm sure that you, as an architect and a photographer, and in today's digital world, also have many questions that you can pose to Enric or also Elena, or that we can share all together.
Yeah, sure. Thank you, Ivan. Thank you, Miriam and Labóh, for inviting me. Yeah, exactly. My question is about sometimes all these legislation. It seems that are made for another era of before internet, no? And now with internet, we have this explosion of situations that enters in problematic situations with the rights of the photographers and the rights maybe of the architects, but in my case of the photographers I made. No, the fact is that when we were in the analogical world, it was quite easy to control the publication of your images, no? But what happens now with internet, where you put your images in your website, and then people make captures of these images and then reproduce it in other blogs, and then they start to go around the net without any control. I'm not sure that is bad, but it's something that it might concern all the photographers, and also what happens with all the legal situation around the social networks. No, let's think about all these long texts you agree before entering to Facebook or to Instagram, that I think they allow to use all you put there in their own interest. No, so we have found some artists that they simply take pictures of they take out pictures from Facebook and Instagram to make their own creations, but in fact sometimes they are images who has a very clear author, no, which is the photographer who took the picture. No, so now we are entering, or we are already entered some years ago, in a world where all the copyrights and everything with the media, internet, and all the flow of the information makes very difficult, I think, to control all these problems. No, but in another way, I don't think if it's a problem. No, it may be an economical problem to control this, but of course the diffusion of culture, it's very interesting. So there's also the theme of the Creative Commons. No, all these new possibilities to give different levels of copyright to some images in order to make it to make it useful for a lot of people. No, so I would like to ask Enric what he thinks about all these questions, and if he has some cases concerning all this situation that he could explain us. Thank you, Enric.
Hi, thanks, Adria. The fact is that the internet has not changed the basic principle by which the author has the right to authorize the use of his work. Internet has brought good things and bad things. The good thing is that every photographer can introduce watermarks on his or her photographies and know exactly where the photographs are being used. And then he or she may tolerate such use or pursue. Of course, the bad thing is that it is so easy to copy that there are very many, let's say, minor infringers. So your photographies can be seen around the world very easily. And you will not file an action against every of those minor infringers because it will not be practical. That's the problem of the internet. But when you see that your photography is used on an intensive and economic way, then you should not hesitate to make your rights known and enforced and declared. There are photographers which set up a system of crawling through the internet in order to know where their photographs are being used. And then a system of communicating or sending an email to the person that is using incorrectly the photography may obtain the seize of this infringement. You have talked about social networks. The fact of opening a social network account implies the acceptance of their rules. Their rules, when you read the small print of the license, is that you grant a license to Facebook or to Instagram or to whoever, but to them to use the photographs for their users, but not to anyone. So, for example, now we are on YouTube. If anyone takes a screenshot of this image and uses it, that person would be infringing the rights of the photographer. You have talked also about Creative Commons. It is a possibility by the author, by the right owner, to decide to put, let's say, on a free basis, on a non-restricted copyright basis, his or her images. So there are certain photographers who keep, for example, if you do 100 photographs, 90 of them on a copyright restricted basis and 10 on a Creative Commons to be freely used on Flickr, depending on the license that you want to use on Creative Commons. There are several licenses that you can choose, and you can, let's say, unlock the copyright system.
Okay, thank you.
Alejandra, you also work as an architect in a big office in the metropolitan area. And therefore, sir, you have also had many different situations. And also because you have many projects dealing with public space, I guess. So there's the rights of the photographers who you asked to take photos of your buildings and spaces, but then there's also your own kind of authorship on those works. Which questions and which situations have you kind of had to tackle with, and what would you like to also ask?
Well, first of all, thanks, Ivan, the Mies Foundation, Labóh, Miriam, to give us some voice in this topic. Well, I can say I can write a book about all my experience between architecture, photography, dealing with all the stakeholders in the whole process of the photography report. I agree with Adrià. I also agree with Enric with all the topics that he put on the table, shed light into. And I would like to take a perspective more into the business. I would like to speak to the business-to-business relationship between the photographer and the architect, because I think there is a small or big hole in this area, because architecture and photography businesses have changed so much in the past 10 years. I have started in the communication department 10 years ago, during the past crisis, and I have seen how it changed radically from the roots. Where do we publish? Who is asking for the pictures? How do we make the report? How the technology have changed, the difficulties and the easiest around the photography itself. I have realized that photography is not just product, an artistic representation of the building or the public space, but it is a tool. It is a tool for us, and not only for us, the architect. It became a tool for all stakeholders in a construction process: the builder, the industrials, not only the editorials, the platforms in internet, Pinterest, Facebooks, Instagrams, and all the places where an architecture picture can end up. So when I study the lags and the problems that I work with every day, I find a problem that relates to not being aware that we are working as businesses. And because it is a business, the photographer is a business and an architect is a business, we need to find where what should we offer. The photographer, what should offer and what the architect should offer. I think the problem is in the service that we are that the architect is asking for and the photographer is offering, because we architects in our office I find myself as a ball joint between the photographer and the other stakeholders, and I find myself also working most of the time for the photographer and not the way around. So I would like to ask how the contract can reflect this big change that the photography report as a tool or as a product has become, because I can read the rights of the photographer in the contract. I can read the dues, my dues as a client, but I cannot see what happens when I have to answer like 10 emails per week that relate to another 5 or 6 emails relating to each request that finally report to economic gain only for the photographer, not for me, because they are not media that ask for my work as an architect. They want a picture to show their, for example, the builder. The builder wants to show the buildings that they've construct. So I'm a part of it, but it always relates to the same question: it's who works for whom here. And because I am a big department and I have people that helps in everyone has a view in the department, I have somebody working for it, and it's no problem. My photographer, it became a friend because I talked to him more than to my mother. He always ends up saying, okay, te debo, there is another gin tonic that I owe you for this. If I took all the gin tonics that he owes me, I will end up in AA with a big problem. So we laugh about, and we finally achieve a very nice relationship where I ease the work by a non-legal agreement between us. But I think that we should think about how can we put that in paper, how can we specify, because the business has changed too much and we still use the same contracts that 20 years ago. And I think it's not good for any of us. So the question is, how can it change legally? Because I do the things unlegally, without a paper. And it works for me, but I think that I cannot hire another photographers because I should become friends with them to start this good relationship. That's it.
Enric, how do you think agreements should be kind of pursued? And Elena, maybe also from the association, is it really absolutely necessary, or can this kind of more word and kind of direct contact with people be part of the agreement or the relationship?
Thank you, Alejandra. I hope you can you hear me? Well, my network is not very well. Okay, Alejandra. The law is not going to change. What you have to change is the balance between, because the rights are the same, the rights of the architect and the rights of the photographer. I said before that the ownership of the copy, the ownership of the photographs, the masters or whatever, do not give you the rights. So when you, as an architectural firm, are negotiating with a photographer, you should find with the photographer a good balance of the exploitation rights that you want, essentially reproduction, distribution, not transformation, probably because the photographer don't want his or her photographs to be transformed, and maybe a reservation of certain rights for the photographer. For example, the photographer may want to keep the right to expose publicly the photography, to have the photography on his or her website, to make books, uses that are not conflicting with the uses that you want. So
Okay, we have lost, unfortunately.
Equitable thing should be to find you follow again. The good thing would be to find a balanced contract which spreads the rights of the photographer, certain rights, and the rights that you want to use on future occasions. So in order not to have to ask for permits every time you need an additional use.
Thank you, Enric and Alejandra. Afterwards, we can follow up the conversation. First, I would like everybody to kind of make their own questions, and I would like to continue with Ducho Malagamba, also an architect and a photographer. And Ducho, you worked at MBM years ago, and you've seen things change a lot, obviously, and also from kind of drawing, probably in the office, to taking photographs of the works in the office that you work for, maybe, or also of the work of many other people. Thank you for being here.
Hi to everybody. Of course, I wanted to start thanking Ms. van der Rohe and Labóh for this opportunity, but now I'm taking away this thanks because you're just calling me old. So it's not very fair to do that. But anyway, no, seriously. Just to quickly answer to your question, no, I was working as an architect in MBM, so my career as photographer started before, after that experience. So it was just two different words at that point. Well, after this interesting, of course, for us, very interesting discussion about copyright, I think that it would be interesting to move one step backward to have a better look at the whole picture of the situation. As Enric said before, copyrights are the instruments that somehow the human gender designed to protect creation. This translated to the architecture photography world means to protect and preserve the work of freelance photographer. Because I was a little surprised with Alejandra, what she was telling us, because in my experience, it's quite normal then when an architect is committing the work to a photographer, is somehow reaching a deal with him, and in order to use the photographs he is producing for them. So it's more, for me, the question of copyrights is much more interesting for freelance photographers. That's because I conceive my work as an architecture critic. I feel I am an architecture critic working with images instead that with words. So for me, the only way to be completely independent is to work as a freelance. And without copyrights, this is impossible. Now, I think it's a little hypocritical to be surprised when you just find images controlled and authorized by architects. You will remember, everybody, I'm sure, will remember already Enric pointed it out. Oliver the other day was saying that he has to take picture himself because sometimes the photographs he received are too directed by the architects. So the important point about copyright, in my opinion, is to understand that without a strong defense of copyrights, the photographers could just work for the architects. The society, let's say the small architecture society, the small society interested in architecture, is killing the possibility of a free, independent photography if the copyrights are not defended. So this is my point. I mean, I would push somehow the discussion into the understanding of the fact that the defense of copyrights is something very important in order to have independent photography, criticism done through images. Just after this statement, somehow that I felt it was important to do, there is a question that I would like to pose to Enric, and perhaps also Alejandra could be interested in telling us something else about that. And when there are architects that are very interested in having a strong communication line, they always work with one photographer, they are directing him somehow, they perhaps like, I don't know, just to make an example, photography done without people, with a dull illumination, gray skies, and I don't know, this kind of ideas that are, of course, very legitimate. If another photographer comes and take a different picture, perhaps, let's say again, trying to be the opposite with people, a lot of a live situation, other kind of colors, much more saturation, something else. I would like to understand from a legal point of view, who has the right to push this? I mean, is more important the right of the architect to express their own way of understanding their architecture, or the opportunity that another photographer can have to transmit their own sensation of what he's visiting, what he's saying, or what he's want to show?
I think Enric and then Alejandra, maybe we would like to hear your opinions, and then we will go to Martin as well. Sorry.
Okay, thank you, Ducho. Very interesting comments. In my opinion, the one who can control the photography is the photographer. The architect cannot say, oh, depict me like this or depict me like that, depict my work like this or my work like that. Because, as you said, a freelance photographer, as a creator, has the free choice to shoot the photography as he or she wants. If, for example, a landscape designed by a landscape architect,
sorry, Enric, I think we've lost your connection. Enric, we cannot hear you. So in the meantime, maybe I will ask Alejandra if you can give your point of view answering what Ducho was saying, and then we'll try to get back to Enric.
Well, first of all, I want to explain a little bit better, which I explained around not being legal. By not being legal, I don't refer to not asking for permissions. In my office, we never give a picture without the photographer permission. This is a line that we never cross. But because there is a problem with the communication with the photographer, like, hey, I need the authorization, please sign it. What is the name of the company that you're giving the permission? It's so complicated, and we are always requested the pictures like for tomorrow or for yesterday. We are starting to have another agreement with the photographer, like he says yes by WhatsApp. And I have an instant solution to my problem to the transaction. Regarding to the question that Ducho put on the table, I think that from the architect's view, the complexity of a photography shooting, or the whole photographs that arrive to our table and we decide. When I started to work differently, when I started to open to this kind of other pictures that reflect the photographer vision, is when I changed it into paying for photography, into paying for the whole report. When I have 10 pictures to choose, I cannot choose only the most beautiful. I have to choose the ones that explain the project, because I need to explain the project. But now with my photographer, which is Antonio Navarro with Mark, I want to say hello to him. And we also work with Jordi Sorroca. They gave me the whole work. So if I have 150 pictures, I will use the ones that explain the project and the ones that show the vision of the architect. But I cannot choose only 10 pictures of sensations, of atmospheres, because they don't explain the whole project.
Alejandra, I think we have been able to solve the problem with Enric. So if you agree, let's see if we can also have Enric's point of view.
Okay, and now can you hear me? Well, Alejandra, I think the problem is not of having 100 pictures or 10 pictures. The problem is having 100 rights or no rights. So the object is to find a balance between the rights of the photographer, which is
Okay, I'm sorry because Enric, it happened again. It's not working. Before we continue, let's say, with the conversation on this right now, I would like to jump in with Martin Boschardt, because he has another role also with the marketing, which is there's the photographer who takes photos, there's the architect who chooses those that he or she wants to show, to explain, as Alejandra was saying right now. But then there are the platforms that also choose from these selections or previous selections, those that they want through their own perspective to share worldwide. Thank you, Martin.
Yes, thank you very much for having me. I mean, exactly as you said, we as a publisher have just another role here in that whole play. And I have to add, maybe, I mean, we are like a small publishing company. You know, when we talked about publishers, or you talked about publishers before, it was about social media, it was about Facebook and all the big players here that like dominate the market, of course. As a small publisher, I mean, we fight more or less with within the same area, but we, of course, have totally different resources at hand to handle that. Now, just maybe as an explanation, we at worldarchitects.com, we provide architects the possibility to upload their portfolios. So a lot of what's going on our platform is user generated, meaning that architects upload the photos they want to show to our platform to be able to publish their works. This, for us, of course, I mean, we rely highly on the architect having the rights to publish the photographs. Most of these photographs were done by professional architectural photographers. So we have those players involved in all of, on a daily basis, we have to deal with that, what we were talking about today. And I mean, to add, we highly respect the work of professional photographers, and we are more than happy to also promote their work and to help them to help them getting a fair deal when they get promoted, right? Or when they get published. But still, we have to rely on the architect. And now, I mean, as we saw today, or also, I mean, as it's clear, we are all not lawyers. So it's incredibly hard also for architects to even think about about the rights involved, as you explained today, Enric, what's involved and what they may do and maybe not do with their works or with the photographers, with the photographs they got. So that's incredibly difficult. And what we are seeing, a pretty new phenomenon we are seeing is, up until now, we were able to, I mean, of course, we get some, from time to time, we get claims about copyright infringements. We can handle them pretty easily with just talking to the people, you know, we search a dialogue with the photographer, with the architect, and then we can settle the issue without big problems, right? But it's about talking to each other. What we see now is we have a lot of, or what's growing, I guess, is they're specialized law firms that just use, as you said, Enric, those crawlers or those online services to search for images for copyright infringements, and then they contact us, often even without really researching the actual situation about the copyright laws or about the copyright situation of the images. So we get, from time to time, we get claims from law firms that represent photographers about works that we publish on our site. And that's, of course, a difficult situation for us, because we would be more than happy to compensate the photographer directly or to find a solution with them. But then, of course, well, then we just have a third party involved there with law firms that make the things just more complicated. I mean, what's your, Enric, maybe what's your opinion on this? I mean, is that from a photographer's perspective, or you as a lawyer also for photographers, is that a thing you would recommend? And at the same time, I mean, is there a way to just avoid stuff like that, or being more into a dialogue?
Iniciar audio. Yes, I agree with you that the best way to solve a conflict is by talking to the other party. I agree with you that when you receive let's say, a kind of an aggressive letter, you answer with an over-educated and pacifical and peaceful letter. It may low down the aggressivity, and the lawyer will not pay for an action. The lawyer will contact his client, photographer, and say, well, do you want to proceed? They have said that. And maybe when the photographer sees that there is a goodwill to solve the things, in most cases, the conflict will be solved, because no one wants to spend money, which is, it may be expensive, a court case, a litigation case, for the use of a photography, with the exception of very, let's say, intensive uses. If you reproduce a photography in a poster and you make a lot of money by the exploitation of that photography, then it is clear.
Okay, it seems like today Enric is only allowed to speak for a couple of minutes, and then we make him shut up. But I don't know, Elena, maybe you also as a lawyer, do you want to maybe add up onto these, onto what is being asked here? Remember to unmute your...
Thank you, Ivan. Yes, I would like to say something about the question said by Ducho Malagamba about who has the right to decide the way the pictures have to be taken. Who has the right to decide if the photograph have to reflect the art of the photographer or the will of the architect? In my opinion, this also happens to the architects when they have to agree with the client how has to be the house, no? How are the characteristics or the design of a house. So for me, this is not exactly a matter of law, and this is something related with the capability to talk, to dialogue with your client. So you have the advantage in that case for the photographers that you are talking to a professional. The architects often talk with non-professional persons that don't have the sensibility with art, no, that also that sure you will have the photographer and the architect. So for me, it's a matter of agreement, and also it's something related with which professional you choose. If I was an architect, I will choose the photographer that usually works with a style, no, with the characteristics of his works that fits with my opinion of my architectural works. I don't think anyone can appeal a law to defend his right to do the work the way he wants. I think as a professional serving a client, you always will have to agree that.
May I say something?
Yes, of course.
Yeah, perhaps I've been a little bit misunderstood in the question. You are perfectly right on what you said if you are talking about an architect commissioning the reportage to a photographer. But I was presenting a different situation. A freelance photographer who is doing by his own initiative the work, and the architect who already committed commissioned to another photographer the reportage. So the architect has his own reportage, a reportage that somehow, as you said, is in good feeling with his interests. And there is another reportage that is done independently. And in this moment is when I think it's a legal problem. Mm-hmm. Because who has the right to do? It's more important the right of the architects who want to express himself in the way he considers has to be done, or it's more important the possibility of other people to show in a different way the work of the architect.
So there are two different ways of express the architectural work. So in order to understand exactly what you are planning, because I'm used to advise architects, not photographers, so I'm not expert in that way. I thought I understood that the problem was in a committed photographer, but you are planting a different situation. Maybe Enric, if it's possible to hear him, will be more expertise to apport his opinion on that.
Okay, I will try to keep the
density 2 minutes.
The gods of the Wi-Fi connected. I stress that the right of the author is controlling the way he does his work, and the author of a photography is a photographer. Punto. If the photographer is taking a picture of a landscape, there is no problem. If a photographer is taking a picture of a building, there may be a problem if the building is inside. The owner or the architect has the copyright of that inside. But when the building or the landscape is outside and accessible from everyone, at least in many countries in Europe, the photographer has the full and complete right to express his or her artwork as he wants. And so he will not, the architect could not say, I'm sorry, you have depicted my building on a way that it's not nice. Say, I'm sorry, I am creating my work as I wish. For me, the right of the photographer in this case goes above the right of the photographer. I'm sorry, Alejandra.
Alejandra.
And I would add something that is every day happening more and more to us, that is the client. We architects sign an agreement of confidentiality. For example, in my office, I always give complete freedom to the photographer. I always give him a couple of tips, like this perspective should be perfect because it explains something that is important for us, but I give complete freedom. But there are places that you cannot reproduce. For example, recently we went to the mini stadium, the new stadium for the Barça, and we had a very specific contract with Football Club Barcelona that doesn't allow us to enter to some places to explain because of security issues. Also in transport buildings like the cruise terminal, which is the police stand, and there are some contracts that closes the photographer freedom, but the rest is completely on their choice.
Yeah, I think that following Alejandra's question and also adding some questions that people are asking now live regarding the client, the relationship, or in fact, one of the questions says, from the photographer's point of view, what are the rights of the owners of buildings? May they claim a part of photographer's licensing income, assuming we take pics in public space? So this also has to do whether the photographs are taken outside, as you were saying, or inside. But maybe we can also kind of clarify what Alejandra was saying or asking, and what this person from online is also asking. Enric?
Enric, no? So,
Enric, is it possible?
shall I clear this? Yeah. Shall I be talking?
Yes.
Okay. Can you hear me? Okay. The thing is that the owner does not have the right on a share of the income obtained by the photographer, unless he negotiates this with the photographer. The owner has a property right to let anyone go into the property. So the inside of a hotel or of a house, whatever, is controlled by the owner on the basis of property right. I have the key, I let you come in or not. But the outside can be freely accessible for anyone. And a photographer can take a nice picture, make a lot of income of that picture, and don't have to share anything. There may be some cases in which commercial use, pure commercial use of the paintings may be limited. But let's say art purposes of photographing buildings which are located in public spaces, there is no limitation, and there is no obligation to share any income with the owner, unless the owner has agreed with the photographer. For example, if the owner lets a film director enter a property, he may say, well, you have to pay me 10,000 euro, or whatever, what is normally in a castle, and you as an owner, as a property owner, may decide what is your fee, but not on the basis of copyright.
Elena, maybe Elena, you can also add something.
Yeah, I would like to add a little, well, something more about that question related with the privacy, the right of privacy of the owners in the case that the building is a house. So I think I advise and advise to architects and also to photographers to be especially careful when we are talking about houses, homes, because maybe the owners has not the right to have an income, a direct income from the photographs, but they have the right to claim for damages, because the right of privacy of his house is something that they have to be able to decide. We have find sometimes cases that architects has present photographs to an award without the agreement with the client. The architect has the rights of exploitation of the building. The photograph has the right one day, to go there, and they had agreed that it's possible to take pictures, maybe to publish them in a publication, and without the agreement of the owner, they use these pictures for other things, like to present them to an award. And we have found cases of claims of damages for the owner related to the right of privacy, not related to the right of having an income directly, but yes, but by this way. And I think that is important to take in account that part.
Adria and Ducho, some people are also asking us that photography is the way through which mostly architecture is perceived or seen, like videos as well. And they are asking if shouldn't a photograph of a building be considered a co-creation between architect and photographer?
Ducho, do you want to start?
You first.
Okay. I don't know if no, I don't think we have to say that it's a co-creation, okay? But it's true that to make the pictures of a building, it's in a way the end point of the work of an architect. So most of the many times when I go to make the pictures, the architect comes with me at the beginning to show me the building, for example, and he usually says, well, today is the last day of my relation with, from that day on, after making the pictures, the life of the building will start for itself. No, so his works finished when we make the pictures of this building. No, so in a way, I feel part of the process of the architect, which finishes with something that he can show. Of course, it's better to be able to go to make to see the building itself, no, in live, no. It's the experience of the architecture cannot be reproduced by a photograph, no. But the 90% of the people will know about the building through the pictures. So in a way, we are like closing the circle that has started with the project, no. So I don't know if it's a co-creation, but I really feel a little bit in the stream of the creation of a building. No, sometimes I say that I feel more like I still feel like an architect, even if I only do pictures. So in a way, yes, we are in the creation of the building. Not, in fact, it's true. I think in a way it's true that making the pictures actually, or making the work to communicate a building, it's part of the building itself. No, and I have to say that even if we try to make our own creation, as Duccio said, some architects are really controllers, and they don't want, and they really want to control how this building is gonna be communicated. No, so usually I work with people that we agree the way we have to do these things, but anyway, they are till the end of the process there, no. And yeah, in a way, it's part of architecture making these images, at least for me.
To add something?
Yeah, I can say that again. There is the big difference between being commissioned by an architect or working by yourself. I mean, this I think it's the important point. But there is another thing that I would like to stress, is that I think there is somehow a lack of education also among the architects about how different is the work of a photographer compared with the work of another photographer. I was preparing for this summer workshop in the University of, in the Architecture School of Barcelona, that has been cancelled for the coronavirus. And for this workshop, I did a very interesting experiment. And I asked to Ivan Ban, Hafton and Crow, Nelson Garrido, and myself to put together 4 different views of a well-known building. And the reportage were among 40, 50 pictures, each reportage. And the incredible thing is that just perhaps one picture could be compared, really, one side to the other. Every other picture were absolutely different. So the interest, the focus, the lights, the framing, everything was so different that I think that if you just have a look at this situation, 4 photographers, 4 reportage, the same building, you have the answer. I mean, of course, the architecture is the basis we are working with. And we have to recognize, of course, the value of the architecture and of the architects, of his creator. But call us co-creator, I don't think it's the proper way to define that.
I think I don't know if I can say something. That because I really agree with Duccio in this fact, and in a way I sometimes compare doing architecture photography to musical interpretation. No, it's like we have this basic pentagram, no, this basic music that has been written, and we give an interpretation of this music that the others is the thing that they can listen to. So if different interpreters interpret this music, always the music gonna sound different, but it's always the same theme. No, in architecture photography, I think it's something like this. We can have a golden variation of Bach in a site, and then interpretation of Barenboim in another. No, so the interpretation can be really different, but the subject is always we can listen above this interpretation, this line, but the reaction is always to the interpretation also. So we have this mixture that I think it's really easy to understand through music. No.
Yeah. Just one thing, I forgot totally to also ask Miriam Jordan, who has been organizing all this, to participate. So Miriam, please.
Don't worry, Ivan. It was so interesting to listen to everybody. And so I can also a bit take parts of each interventions, just to point out what Alejandra said about the building and the owners. Just I want to say the same, that in many cases, from my experience, it happens that the authorization to take the picture came through the architect negotiation with the client. No, the architect has this relation with the client. He asked, please, can we take the picture inside this hotel, or in the case of the stadium, no, that Alejandra mentioned. So probably the answers is the contract, that everybody has to look to the contract that architect and photographer and probably owner sign, because the point is that sometimes architect told me, okay, these pictures were taken thanks to my negotiation with the client, and now the photographer want to use for other purposes, or also selling a part of these pictures to another client. This is a technical puntualization. But what I would like to say now, and bring my experience as a communication agency, press relation agencies, and also because we are in architecture and the media conference, is that there is for me a big sometimes contradiction between the desire of visibility and dissemination, that is a desire that both architects and photographers are. So my clients sometimes are architects, most of the time, or institutions dedicated to architecture, and sometimes my clients are photographers. And both of them, they want their work is disseminated as much as possible in a high quality way, of course, in good newspapers, good magazines, or good online platforms. And on the other hand, there is the desire of protection and control that goes together with the copyright issue. So I want just to point out this contradiction in a way that is very important to clarify in the contract, in the relation between architects and photographers. And it's true that it's not easy at all for example, a small practices, a small architecture office to have a great knowledge about the law and the copyright, and to have access or to have the advisory of a lawyer. So this is a point that for me is quite important. And also on the other side, sometimes there are photographers, young photographers, or also not young, that for them it's difficult to have the advisory of a lawyer. So this is a point that for me is very important, that to be conscious that the other side is the newspapers or the magazines that ask me picture to explain projects, and these newspapers, media in general, they ask images free to use. So I want just to put on the table the complexity to manage the relation between these three subjects: architects, photographers, that in some cases should have the same purpose, the visibility, and also the necessity of media that to explain and to disseminate architecture. Many times they ask images free to use.
Enric, you wanted to add something, please.
Yes, I was listening to the very interesting talk between Lucho and Adria about the working collaboration. Concerning the music performance, I would like to stress that the musical performer will never be the author of the composition. In the same way, the composer will never have the rights on the performance if the performance is not carried by the composer. In photography, the working collaboration in any work is collaborate in the work you're doing. A collaboration in photography would mean that the architect would choose with you.
That was the end of the sound with Enric. Unfortunately, we're sorry for that. Because what we'll try to do is, and anyhow, afterwards, try to get back to him and maybe record some of the answers that we have not been able to listen to and put them online as well. Because now following, and let's see if in the meantime we can get back to Enric. Some people were also asking, and I think it's connected to what you were also saying about, let's say, the rights of the computer graphic artists, those that make 3Ds or renders for architects. At which kind of situation are they as authors, let's say, of a certain interpretation of a work of an architect? Maybe Enric, can we try? But it doesn't work, unfortunately.
Ivan, I think we can do what you suggest. So also for the question from the public, we can ask later Enric to better answer to our questions and to the questions of the public. And I'm sure that our marvelous technician and streaming support will help us to put it together and so to publish the video with these answers a bit more clear.
I want to ask one last question to Elena, and then we'll wrap up with all of you. Elena, there were several architects texting me directly on WhatsApp asking, hey, what rights do we have when they publish our drawings? Do we also have any kind of rights, economic rights? Some of them were asking when somebody publishes.
In my opinion, yes, especially because when we are talking about projects plans, the legal treatment of these documents is more or less the same that other written arts. So the exploitation rights of these plans are from his authors, and the publications that are exposing these images or archives need the previous authorization of the author, because the distribution, the reproduction, the public communication, all the economic rights of the creation belongs to the author, and it has to be a previous thing. So anyone can publish your plans without your consent.
Okay. Thank you very much.
Sorry, it can be that you have already given that right to another person. So unless if it is under an agreed condition, so you have signed a contract giving this right to your client or to a publication, unless you have already done that in a written way, preferably, the right is yours.
Thank you. Yeah. I think I'd like to ask Martin. Would you like to add something to the discussion or from the answers that you have received? And then we'll ask each one of you to also wrap up because it's been an hour and a half already. I think it's been very interesting, but always online. People see things sometimes differently. But Martin, please.
Well, thanks. It was super interesting to listen to all these meanings and all the interesting topics that were discussed. as I said before, I mean, for us as a publisher, it's just very important to be part of that dialogue and to be able to like collaborate on solutions on that, because there are many topics that are not easy to solve. And when I see what's happening with just legislation, I mean, it's difficult for us as really actors who work with those topics on a daily basis, to be on the same level there.
Thank you. Maybe Alejandra, would you like to add something?
Well, I want to make sure that everybody is feeling right about the idea that the architect loves the photographer view of their building. This is why we hire them. This is why we ask them for their vision, their point of view. But we are not in the 20th century, and everything has changed a lot. And I think that we should think, if all the channels of reproduction of these pictures are so different from 10, 20 years ago, we have to renew all the system of authorizations, of rights, of asking, of letting, of giving for free or asking money for the pictures. And because it's not anymore publishing in books, and it's not anymore money. The money has changed from one place to another. Has changed from the editorials to the stakeholders, to the people who want a picture for their businesses. I think that we need to put this on the table and start asking from the rights to the right persons, or the right interlocutors, como se diga.
Thank you. I would also like to hear something more from you. Yes, the sound.
Yeah, it's okay now? Okay. Well, it has been very interesting for me to be in this workshop. You have to know that we jurists, one word that you have said, we can spend one day debating about that, about originality, about collaborative work, about exploitation rights, moral rights transformation. We can spend one day debating. So these are very deep issues in law. Here we have synthesized and put these problems into your practical day-to-day issues. And it's very interesting to share all these situations and know and debate about the problems that you have on a day-to-day practical basis. No? So I would only say that the law is there, but the parties can tailor the law according to their interests. So that's the importance of contracts. Contracts that will tailor the interests of the photographers, of the architects, and of the owner in case. So that's all I would like to resume.
Thank you, Enric. And Ducho Malagamba, can you also add something?
Yes, I would like to say something very low level. That's mean, well, somebody has to pay. I mean, this is the problem. I mean, I'm a little surprised what Alejandra says, because it's so evident. If the architects buy the copyrights to the photographer, then they have the opportunity to use the picture or whatever they like. The point is that the architect don't want to pay for buying for have a complete sessions of the copyrights of the images. This is the point. If the architect wants to pay just a part of the work, or somehow have the work done for free because then the photographer will be able to sell the picture to magazines or something else, then is when you have this kind of problems. I mean, I think it's quite easy. Our work, if the architecture society is interested in having a continuity in this profession, somebody has to pay. So all the architects are going to buy, as is traditionally done in the United States, for instance, they buy all the rights of the pictures, and then they do with the picture whatever they like, or the copyrights are sacred, and everybody that uses a picture has to pay the copyright to the photographer. I mean, I think that's it.
Alejandra, and afterwards Adrià.
I have no confusion about this topic, about who owns the picture, and that we have the opportunity to buy the complete rights of this picture and then to use it as we want. I think it's a little bit too expensive to spend in. It depends on the project that you are photographing. It's obvious, but I was speaking about there are more opportunities right now than 10 years ago to have a reward of these pictures, because the stakeholders, the people that want these pictures, are another ones. Okay, it's not more into the publishing business. Publishing business have no money or have the will to pay. They always ask us the pictures. Okay, we don't have budget. Can you please talk to the photographer to give us for free because it's we are small and blah 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 blah. 3-4 mails in between. They still not having money, but the money is somewhere else. It's changing, and I think the owner of the building, the constructor, the one that built the facade, the one that put the pavement. I answer like 10 emails per month, giving the address of the photographer to this person that asked a picture for their website or a publication.
I want to add also
just one thing, because what we are absolutely aware is that this will bring a really interesting discussion and debate. But what we will want to do, and first we want to hear also Adrià, Elena, and Miriam. What we need to do for sure is very, very soon meet back here or in here or wherever I am, and have that discussion. It is absolutely necessary to continue this discussion because there are things that have to be clarified or also have to be discussed. But as time now, we are a little bit over the time. Let me ask Adrià, afterwards Elena, and then Miriam.
Thank you, Ivan. Yes, I really like to discuss about all these items, and I think that I'm waiting for the answers that Enric will record later, because I think there are many interesting questions that would like to know his opinion. And yeah, but the truth is that what Duccio it's pointing here, it's about where is the money? No, where is my? It's one of the main questions about all that. No, all this world is changing. How the magazines that were supporting some kind of net of photographers, now they can't do it anymore. But and it seems that they are making a favor to the architecture society by making their magazines, because they are not really long anymore a business. but they are many ways, like websites that first were like just, no, we just put a blog, or it's just we put it on the website, and now they are having a huge amount of advertisement on it, that they are surely having more incomes than the magazines itself, but they are into this relation with the architects and the photographers that there are no commercial relations. So it's all as Martin were explaining before, no, how these things are organized, no. So it's really a theme that I think all of us thinks that photography or architecture photography has their interest on explaining architecture. Architects they are interested also. The public is interested, but how we manage to organize all these things is something that is moving from one year to another, and it's very interesting to see what happens in 10 years, how this thing is organized, because really now we don't know very clear where it's going.
Thank you, Adria. Elena, would you like to add something?
Yes, thank you, Ivan. Finally, I only would like to invite the architects to think at the beginning of the relationship with the client, and to add to the contract a special clause related to the rights, to the copyright, in order to prevent the problems in the future. In architecture, it's usual not to have a specific contract with the client at the beginning sometimes. I would like to invite them to make the effort to do a contract and to have a specific clause about that, in order to improve his rights, the protection of his rights in the future. It's something, it's necessary to do some pedagogic about that. Anyway, I invite also them to contact with us, with the college, with our association, and we will give them advice with all their doubts and whatever it's necessary to talk about, in order to try to solve and to protect their rights properly. Thank you very much.
Thank you, Elena. Miriam.
Yeah, I think that we received a very nice suggestion about a parallel conference that should be architecture and the money, because this is a great point that sometimes is pointed out from both architects, photographers, and it's true what Alejandra is saying. I mean, for my experience, normally media ask me, so the problem is that who pay for these images, and who support the dissemination of good images of architecture building. And also another things I just want to point is that also it's true that the architects, my clients that are architects sometimes, they do not only pay the photographic shooting, because after they pay PR agencies monthly sometimes to move and to disseminate these pictures. So from my side, we always defend and the author of the picture. So we always ask to publish the name of the photographer. So just in the contract, that for me is the point we learned today, that is very important to fix this contract of rights and agreements. It's important also to take in account that there is a work of dissemination, because it's not enough to, I mean, when you have a good pictures, then the question is who will see it, depending on where you publish it or where you show it. So the work of dissemination is a work that has also to be taken in account in the evaluation. So thank you very much, because it was so interesting. And as Enric says, we could dedicate one day or more to each of these issues that we discussed today together.
Yeah, thank you very much, Adria Goula, Alejandra Liébana, Ducho Malagamba, Martin Boschart, Miriam, of course, Giordano, Enric Enrich. It's been fantastic. It's been an hour 45. From my point of view, it was like 15, 20 minutes, really fast. And remember that this afternoon we have at 5 p.m. Central European time, Barcelona, Paris, Berlin time, the closing conversation with Ivan Ban, photographer from the Netherlands, with the presentation, The Role of Images in Telling the Story of an Architectural Work. And it will be introduced and moderated by Eva Porepska, who's the editor-in-chief of Architectura Murator magazine, published in Warsaw. So we meet again a little bit later, and thank you very much to all of you for also following us.